Okay, so chapter 10, we're going to look at the law of agency today. And then on Monday next week, or next Monday, we're going to look at sole proprietorship and partnership. So we're going to have half of the chapter today. So the law of agency, first of all, we're going to borrow some concepts from contract law. And this will make the law of agency a little bit easier on us. Not only this, the law of agency will also help us understand partnership when we look at partnership as a business entity. Because partners, they are agents of one another. So it's important for us to know well the law of agency. Okay, how do I make this disappear? Yes. Okay, so what are agents that you know? I think I had, sorry? Real estate agents, yes. What do they do? What do real estate agents do? What does?
Sell you the property.
Mediate the deal. They sell or buy property, real estate. Does the real estate belong to them? No, belongs to someone else. They are representing, right? Yes. Someone said insurance agent. Is the agent the owner of the insurance company?
They offer the insurance to the
Yeah, so they offer insurance from a different company. So that's what an agency relationship is. There's an agent that represents and acts on behalf of what we call a principal. The owner of the house is the principal. The buyer, the potential buyer, is the principal. And they will have an agent working and acting on behalf of them, dealing with third parties. We have travel agents. Well, when you went to Tim Hortons, did you talk to the owner of Tim Hortons or you talked to an employee? An employee. Was the employee representing Tim Hortons? Can't we say an employee is also an agent in some circumstances? Yes, we can. What about me? I'm an employee of BCAT. Am I BCAT? No, I'm not. I'm an employee, but also an agent of BCAT because I deal with third parties on behalf. I represent BCAT. I act on behalf of BCAT. Does it make sense? So an agency relationship, there's three parties involved. The principal, the agent representing the principal, acting on behalf of the principal, when they act, when they deal with third parties. Right? A lawyer, when a lawyer represents a client, is the lawyer an agent? Yes, they are. Because the lawyer is not in court talking about their own issues. It's about their client's issues. But they have power to talk about the client's issues. An accountant. When an accountant represents a company with CRA, Canada Revenue Agency, they are also an agent. So those are examples of agency relationship, okay? And in some circumstances, the principal, they will be vicariously liable for the wrongful conduct of the agents. We discussed already vicarious liability. We discussed mainly on employment relationships. So employers are vicariously liable for the wrongful conduct of their employees if the wrongful conduct is in the course of employment. So vicarious liability may also be applicable to principals in agency relationships. How is an agency relationship created? Well, it will be created, it will be formed by granting of authority. Can I be your lawyer? Let's say I were a Canadian licensed lawyer. Can I be your lawyer? Yes. But what do you need? Do I need to be your lawyer? Contract, okay. But what does the contract give me? A right. We're going to say power or authority to represent you. So I can be your lawyer if you grant authority to me. Can I represent your issues with the School of Business? If you give me authority to, yes. And if I accept the authority, yes. So that's how an agency relationship is created. The principal grants authority to their agent. And then their agent acts, represents the principal. Can you give me an example of a purchasing agent? What is a purchasing agent? What does a purchasing agent do? They buy the goods for the company. Who's the company?
The one who will
Principal. Let's just use the terms for the agency relationship. So yes, a purchasing agent purchases goods, raw material, whatever they are, to their principal. To the principal they represent, they act for. What is a selling agent? Someone who sells goods for the principal. So I'm from Brazil. I've been in Canada for almost 8 years. Let's say this Brazilian company, they want to sell their goods in Canada. They can hire me, if I'm available, to be their selling agent. They want to sell bananas. There's a lot of bananas in Brazil, by the way. So they want to sell bananas in Canada. I can work for them, but not work as an employee, work as a selling agent. They can give me authority. Hey, you can sell up to certain tons of bananas per month under certain price. They give me authority. So how is this granting of authority? How does this happen? So it may happen by contract, which is usually express or implied contract. It's an agreement. And then the agreement will detail the extent of the authority. What is the extent of the authority? If I am your lawyer for a tort lawsuit, I have authority for that lawsuit. Not to deal with all issues in your life. No, only for that. If I'm a banana selling agent, I have authority to sell bananas, not coffee, not apples. So the extent of authority. The extent of authority could also be in monetary amount. Could be 500,000, could be 10,000, could be whatever the amount is. Why is the extent of amount important? Why is the contract important? Why? Why are terms of a contract important? Can you just say again?
Didn't breach the contract.
To avoid parties to breach the contract. Or if parties do breach the contract, the victim has a remedy. So the company, my principal in Brazil, they gave me authority to sell up to 1 ton of bananas per month. If I sell 2 tons in a month, what did I do? I breached the contract. Can I be sued? Yes, if my principal suffers damages, they can sue me. Okay, so that's granting authority under contract, and then duties will be there, nature of payment, etc. Power of attorney is this agency contract in writing. So power of attorney is when the lawyer represents you, when the accountant represents you or the company, when a person represents another. Well, I can represent you, you can represent me if I give you authority. So authority may be actual or may be apparent. Actual authority is the one that is in the agreement. The agreement may be verbal or in writing, but that's the actual authority. When I was hired by BCAT, my offer letter, it said I would be delivering law classes. That's my actual authority. I cannot teach payroll, financing, whatever they are. Law. I can only teach law and a little bit. So that's my actual authority. Does it make sense? Again, sell bananas, sell the house as a real estate agent. So that's the actual authority. If an agent exceeds the actual authority, they are personally liable because they breach the contract, as we just said. As an agent, if I cause damages to my principal within authority, my principal is vicariously liable. So both my principal and I, we are liable. But if I cause losses to third parties while going beyond authority, then my principal is not vicariously liable. I am liable personally. Okay, you had a question?
If I own a business and I have a company lawyer, like a specific lawyer or law firm is connected to our company. If I have a problem, we write a contract, right? And if that problem is resolved and another arises, do we have to contract again or not?
It depends on the terms of the first contract. The answer is yes or no. It depends. The scope, it depends of the scope of authority that you have with that law firm.
If we give them that full authority,
Then,
they will
yes,
represent each and every case, right?
yes.
If I don't tax for the clients, if something's gone wrong, did they sue me or the company?
Okay, so as an accountant, you prepare the tax return to your client, and then you do something wrong. What is this? Okay, it's a mistake. In law, what is this mistake?
He didn't perform to the standards.
Okay. Sorry? Negligence or professional liability. Yes. So you would be sued under tort. You are not sued under the agency agreement. Okay? Because as a professional, you made a mistake, unintentional mistake. Okay? So it's different from here. Are we good? Okay, so actual authority, as I said, could be expressed, could be implied, but it's clear, it's known, the authority. However, apparent authority that gives rise to estoppel. So estoppel happens because of apparent authority. What is apparent authority? Apparent authority is the authority from the perspective of the third party. Regardless if the agent has actual authority or not. It seems complicated, but it's not. When you registered to this course, was my name there?
Yep.
When you saw the course outline, was my name there? Is it not apparent to you that I have authority to teach this class? You don't know if I have authority, actual authority or not, but it's apparent to you that I have. Because my name was in the registration link. My name is in the website of BCAT. So from your perspective as a third party, I have authority. Okay, let's go simpler. You go to Tim Hortons. When the cashier charges you $3 for coffee, is it not apparent to us that the cashier has authority? Do we know if they have an actual authority or not? We don't. But regardless, because it's apparent to us from our perspective, because they have uniforms, because they have the ability to open the cash register, etc. It's apparent to us that they have authority. Does it make sense? And with apparent authority, the consequences is estoppel. What is estoppel? The consequence is that the third party will rely on the representation of the agent. And the principal, they cannot deny the agent had authority. So if I mark your next exam, A+, 2 stars, all of them, BCAT, they have to accept. I'm their agent. They may come and discipline me, they may work with me, but because of apparent authority, whatever I do on behalf of BCAT binds them. They cannot deny. The same thing applies for a purchasing agent, for a selling agent, for Tim Hortons employee, for whoever works or acts as an agent. Does it make sense? So the difference between apparent and actual authority. This is what you should know. An apparent authority does not require actual authority. Okay, because it's apparent to the third party. Okay, was there apparent authority or not? Well, courts, again, they will apply the reasonable person test. Is it apparent to a reasonable, prudent person, or not prudent, but is it apparent to a reasonable person that that agent has authority? So that's the test they will apply, if needed be. Agency can also be formed by ratification, in other words, confirmation, and also by necessity. By ratification, by confirmation, usually when the agents go beyond authority, I can sell up to 1 ton of bananas per month. But let's say I sell 2 tons. My principal, even though I have gone beyond authority, my principal may be interested in selling double. So they may confirm, they may ratify. They don't need to, but they may. And that confirmation, ratification makes the deal by the agent, even though it's beyond authority, makes it legal, binding. Okay? Formation by necessity. Not so common nowadays because of the telecommunication means. But in the past, 15 years ago, there would be this driver with a full load of bananas, and they would be stopped because of a snowstorm for several days. So by necessity, they would have the power, the authority to sell the bananas, to donate the bananas, to do something to avoid as much loss as possible. One situation that is unfortunately applicable nowadays, and we can use COVID as an example. So someone would get COVID, they would be hospitalized, and all of a sudden they would go to ICU. What about their financial issues, their dealings? So their partner, their spouse, they get authority by necessity. So they can act, represent their spouse or partner that has been admitted to ICU temporarily. Okay, so this can also be used there. So those are ways in which an agency relationship will be formed and ways in which authority will be granted to an agent. Think about this situation and tell me if the manager is correct or not. Just wait one more minute and we'll discuss.
Remember how you work, have a company as a tax person.
Okay.
If you buy the professional insurance, because when the customer sue me directly.
Well, for some professions, you are required. For others, it's highly advisable. And sometimes insurance is given as a benefit by the company. Some companies, I would say smaller companies, they would require each professional to have their own liability insurance. Okay, so what do you tell me? Is the manager correct in refusing the deal?
No.
You're saying no? The manager is correct? Okay, so the manager is correct, the manager is not correct, not correct. Please raise your hands if you think the manager is correct. Raise your hands if you think the manager is not correct. Okay, why do you think the manager is correct?
Because he gave him a limit of 50. He
Okay,
can't sell anything above 50.
okay. What else? What are other considerations? Any other reasons? Yes, please. Sorry?
Manager didn't approve the discount.
The manager didn't approve the discount. Okay, I'm just trying to get a pen here. Yes, I do have. Okay, employer. Employee. There's an employment agreement, right? The manager, on behalf of the employer, gave instructions to the employee. Under the employment agreement, is that right? Instructions. Do these instructions bind third parties or only the employee?
Only the
Why only the employee?
It is under Snowfield and many more, the suppliers and the third parties have no liabilities based on the employee told the employee, and if the employee does something and not following the employer, that does not bind them to do something that's bad.
Okay, but we can get even closer. There's a concept that says that a contract is only effective to the parties to it. What is this concept known of? Privity of contract. So the limit does not bind clients. So that's the first thing. The fact that the manager told the employee is irrelevant for the clients. It is relevant for the employee. The employee may be disciplined. The employee may be sued for losses they caused. Okay, are there other reasons you believe the manager is right? Because that reason, as we just reviewed, is not valid. The instructions. And see, it's not a matter of being right or wrong. We're debating, we're learning. Why do you think the manager is wrong?
Because we still.
Because of Stoppel. And Stoppel is related to actual authority or apparent authority?
Apparent authority.
Apparent authority. Was it apparent to the client that the salesperson, John, had authority to give as much discount as they wanted? Because there was no sign saying limitations. So based on apparent authority and Stoppel, you are right. The manager is wrong. The manager should go ahead with the deal. How could you avoid this situation to happen again? At the end of the day, this is more important. So we learn from case law what we should not do in the future. So how could you avoid this to happen? Anything. Close the store during lunch, okay? But you may be losing clients. But yes, that's an option. What else?
Increase the selling power of the salesman,
Increase?
selling limit of the salesman.
No, but you don't want the salesperson to sell over 50. How do you avoid this to happen? So one way is close the store.
Make a written agreement with the employee.
If you make a written agreement, you come back to this situation, not effective to third parties. How can you inform third parties? This person has no authority over 50.
Take a
Put a sign, put a big sign. Also have the salesperson to wear a tag saying, salesperson in training, limited amount for sale. Or do not let the salesperson to be by themselves. Right? Be with them. Those are ways you could avoid apparent authority. And you would avoid this loss. Can the employer deduct 400 from John's wage or salary?
Yes.
No. Salaries, wages, pay stubs cannot be deducted for losses employees cause. How can the company recover the 400? Sue the employee. They usually don't do this, but they could. They would have grounds to sue. What they usually do is they would discipline the employee. They would give the employee a verbal warning, a written warning. Hey, you went beyond your limit. If this happens again, you're going to be suspended. You will not pass probation. Is this clear? So if you are a business owner, be cautious about apparent authority to third parties. Okay. All right, moving on. If you need to leave it whenever you want to. So now let's look at the agent's duties. And remember, I told you in the beginning that partners in a partnership They are agents of one another. So if we learn the agent's duties well, we are also learning the partner's duties. So the agent's duties will be, they have to comply with the terms of the agreement. Well, this we knew already, because we know this from contract law. Anyone who enters into an agreement, they have to comply with the terms of the agreement. If they don't do so, they may be liable. So agents, they are liable personally if they act beyond authority. They may be sued for breach of contract. They must perform their functions as agreed in the contract. They owe a duty of reasonable care. They cannot go against the specific instructions. If my principal in Brazil says, hey, do not sell bananas in the west of Canada, only in the east, because it's easier for me to ship to east, not in the west. Even if I have clients here in the west of Canada, I cannot go against their instructions. I cannot delegate my responsibility. If I go on vacation as an agent, I need to speak with my principal and say, hey, there's someone who can act as an agent while I'm away. Do you agree? Do you consent? If they don't, I cannot delegate. Agents, they owe a fiduciary duty as well. We've learned this in tort. Fiduciary duty is that in-hands duty, is that duty that makes the party to act only in the best interest of the other party, in this case, agent to the principal. Agents, they must turn money over to the principal if they get money themselves. So as an agent, if the third party pays to me, I need to turn this money over to the principal. Then the principal will pay my commission. Agents, they owe a positive duty of full disclosure. So as a selling agent for this banana farmer, if I know that the potential buyer is going bankrupt, I cannot be silent because I know and I have a positive duty to disclose. So I need to tell my principal that their potential buyer is filing for bankruptcy. If they want to sell or not, it's their decision. But I complied with my positive duty. What else? Agents cannot act for both principal and third party without disclosure and consent of both. So I find a buyer here for the bananas, and then the buyer asks me, hey, can you also find suppliers for apples, for coffee, for other fruits? But I'm working for the principal, not for the third party. So if I want to work for both, I need to disclose to both and get consent from both. In real estate, by the way, it's not possible anymore. The law in BC changed. Before 2018, agents could work for both the seller and the buyer. Now they cannot. Buyer needs to have their buying agent, sellers will have their selling agents. Okay. Agents cannot profit at the principal's expense. Agent cannot compete unless they disclose and get consent. And professionals, when they are working as agents, they also have fiduciary duty. Fiduciary duty is automatic. Lawyers, accountants, and others. There's also fiduciary duty that is owed by the federal government to indigenous peoples. And now, with regards to the principal's duties, the principal, they also have to honor the terms of the contract. Well, again, repeating, anyone who is in a contract, they have to comply with the terms. The principal, they have to pay reasonable amount for the services, usually as commission, usually. And they also have to reimburse for reasonable work-related expenses. So you see, there's an extensive list of duties for agents, short list for principals. So if you ever become an agent, make sure you are well compensated because you have a lot of duties. As long as you can, because the bargaining power is usually diminished. The agent may be liable to the third party when they go beyond authority, as I mentioned before. Also, vicarious liability is applicable, but is applicable if the agent is within the scope of authority. If the agent is beyond authority, vicarious liability is not applicable in principle. And an agency relationship will end when the contract ends, the date that is set in the contract, or when parties agree to end the relationship, or if the principal passes away, becomes insane, goes bankrupt, then the agency will end. Question for you. B as boss?
No, it's Donald.
Oh, D, Donald, okay. Do you agree, disagree?
Last one?
E?
Yeah.
An agent
Oh, sorry.
need not
No.
disclose? Yeah, no, this is wrong.
Yeah.
Turn over money, account for money that come to their hands. That's an obligation, that's a duty. All others are wrong. They cannot benefit. Yes, they are entitled to commission. They can act for two principles when there's knowledge and consent. So right is D. Are we good? So one last thing is about this enduring power of attorney. So I just told you that an agency relationship will end when someone goes insane. But this does not apply to an enduring power of attorney. An enduring power of attorney is used specifically for when capacity is lost. Again, unfortunately, someone goes into ICU for a serious condition, so their capacity is lost. Someone needs to take care of them. Someone needs to deal with their issues. So this is not legal advice, but in Canada, it's very important for us to have an enduring power of attorney to someone we trust. Because in case something happens to us, they will take care of our affairs, financial affairs, health-related affairs. So it's very common for people to see a lawyer or a public notary to have a valid enduring power of attorney or representation agreement. Again, this is not legal advice. I'm not telling you what to do, but it's very common. People do this. Because let's say children, their parents, they lose their capacity. Children, they will not have access, even if they are of age of majority, but they may not have access to their parents' money unless they go to court and they get an order from a judge releasing the money until the state is provided, and it's gonna take some time. So in the meantime, it may be needed to get some money from the parents. So with an enduring power of attorney or representation agreement, you could be able to access that money. Okay, again, not legal advice, but something to read about, to think about. All right, I'm gonna stop here. So on Monday, we will continue from types of business organizations.